from media, ladies and gentlemen. It gives me immense pleasure to be here today in Chandigarh at the inauguration of both the first edition of India International Dispute Week and the Chandigarh International Arbitration Center. For me, this occasion carries a personal resonance. It was in the very corridors of the Punjab and Haryana High Court that I started my professional journey. First as a young advocate, finding my footing, later as an advocate general, and finally as a judge of this august High Court. To return now and witness the birth of an institution that seeks to shape India's cross-border dispute resolution framework is both humbling and heartening. Chandigarh itself is no ordinary backdrop. It is a city conceived with deliberations, designed, planned and structured with care. It stands as a reminder that institutions do not arise by accident. They are imagined, built and sustained with foresight. In that sense, the inauguration of the Chandigarh International Arbitration Center here feels entirely appropriate. For dispute resolution, like the city building, demands design, discipline and durability. In a similar vein, the conception of India International Dispute Week reflects an equally deliberate and forward-looking vision. It is rare that we pause not merely to assess the present, but to chart a direction for the next 5 years. The theme of this inaugural edition does precisely that. By framing the conversation around India's cross-border dispute services in the 2026-2030 horizon, the organizers have signaled seriousness of intent. This is not an event assembled for optics. It is an exercise in institutional imagination. It asks us to think beyond individual reforms and toward structural coherence, to consider how litigation, arbitration and mediation must evolve together if India is to emerge not merely as one of the largest economies, but as a trusted jurisdiction for global dispute resolution. Moving forward, allow me to dwell a little longer on today's theme, namely India's cross-border dispute services in 2026-2030, outlook for litigation, mediation and arbitration. I see in that title not merely an agenda, but a challenge. It places before us a question: is India prepared not only to participate in global commerce, but to sustain it when disagreements inevitably arise? We stand, I believe, at an inflection point. The first quarter of the 21st century is already behind us, and in that span, India's economic presence has expanded with remarkable speed. Indian enterprises are investing abroad, foreign capital is flowing inward, digital transactions traverse borders in seconds, supply chains not extend within country, or rather now extend across continents and time zones. A contract negotiated in Chandigarh may be executed in Dubai, financed in Singapore and enforced in London. Such reach is a mark of confidence, but it is also a source of complexity. And complexity, if left unattended, breeds hesitation. Before committing capital, investors and entrepreneurs ask a couple of simple questions, but decisive questions. If something goes wrong, where will I go? And will I be heard fairly? Does your legal regime guarantee me the protection of my investments? So, ladies and gentlemen, it is important to acknowledge that disputes are not sign of weakness. They are natural byproducts of growth. A mature economy is not one that avoids disagreement. It is the one that resolves disagreement with credibility. That brings us to the real issue before us. The question is not whether India can enact modern legislation, that we have done so. It is not whether our courts can deliver principled judgments, that we do so every day. The question is whether our dispute resolution institutions taken together, arbitral centers, mediation bodies, commercial courts, inspire sustained confidence across borders. Of course, such confidence cannot be declared with a sweeping statement. It must be earned. Earned through consistency, through neutrality, through procedural discipline, and through institutional performance over time. It is in that broader context that today's inauguration acquires significance. This is not merely the launch of a center or the commencement of a conference. It is an assertion that India is ready to think seriously about the next phase of its dispute resolution journey. There was a time, and many in this hall will remember it, particularly the senior members of the bar, when India's arbitration regime was approached with caution in international circles. Questions were raised about delay, intervention, and unpredictability. As I had the occasion to flag issues recently while inaugurating the Gujarat High Court Arbitration Center and in 2 or 3 international conferences, including the last one where some of the young friends here participating, the South Asian French Lawyers Association, they met me in Paris. The challenges we face exist on multiple fronts. These include building trust for institutional arbitration, enhancing the capacity of arbitration centers, and the need for greater professionalism. Over the past decade, legislative reform and judicial discipline have worked in tandem. Amendments to the Arbitration and Conciliation Act have tightened timelines, strengthened neutrality standards, and clarified the contours of judicial oversight. As some of our friends from across the jurisdictions were speaking before me, they too acknowledge that courts on their part in India have repeatedly affirmed the principle of minimal intervention while remaining vigilant where natural justice demands scrutiny. That balance is not cosmetic. Arbitration cannot thrive without autonomy. But autonomy, if left unmoved, risks arbitrariness. The task has therefore been to allow the arbitral process some room to breathe while ensuring that its legitimacy remains intact. Ultimately, credibility is not measured by the elegance of a statute, but by the confidence it inspires. Investors and commercial actors look not merely at legislative text, they look at lived practices. They ask whether arbitral awards are enforced predictably or the execution thereof is a tardy exercise. Whether appointments of arbitrators are neutral, whether timelines are respected, and whether courts restraint with consistency. It is in this context that the Chandigarh International Arbitration Center assumes significance. I hope in short you will call it CIAC, though CIAC is called for Singapore International Arbitration Center. But CIAC must not become just another administrative fixture. It must stand for something: neutrality that is beyond doubt, efficiency that is beyond promise, and procedural integrity that is beyond reproach. If it does so, it will not merely serve this reason, it will contribute to India's standing as a dependable seat of international arbitration. Let's remember, India is not merely a hope. India is now a promise on the global map in terms of economic growth, in terms of a robust judicial system, and in terms of an equally effective alternative dispute resolution mechanism. As head of the Indian judiciary, it is my responsibility to ensure that these institutions are equally promoted along with the conventional system. And in that process, I am happy to share with you that even UNCITRAL International Annual Conference is now being hosted in India on 24 to 26 April 2026, for which UNCITRAL requested me about a year back, and I promise that in 2026 I will host this event in India. Having said about the arbitration, let us also consider the other equally effective modicums of resolution without rupture. And when I talk about it, I speak from the close of my heart about mediation. Arbitration is not only one pillar of a modern dispute resolution architecture. Alongside it, mediation has assumed renewed stature within our legal architecture. Ladies and gentlemen, with Mediation Act of 2023, to a large extent, statutory clarity has been brought and foreseeability has also now can be seen through the provisions of this act, and therefore the settlements are not merely on a paper exercise. Those too can acquire a status of enforceable decree. More importantly, it reflects a maturing understanding of commercial reality. And that reality is that not every disagreement requires a judicial verdict. Some require mutual understanding. With the launch of Mediation for the Nation, which I did last year as Executive Chairman of the National Legal Service Authority, every house in India is attuned with the concept of mediation, as that pan-India initiative sought to settle dispute at the Taluka, District and High Courts level through structured mediation efforts. In cross-border disputes particularly, mediation offers something where arbitration invariably fails: preservation of relationship, where parties expect to continue doing business together. A mediated settlement avoids the rupture that even a well-reasoned award may leave behind. If I say it differently, mediation allows resolution without residue. I have often spoken about the quiet moment in a courtroom when a judge senses that behind legal pleadings lies a relationship still capable of repair. I believe that such moments exist in commercial disputes as well. When business partners fall out, the objective is rarely the humiliation of the other, it is the restoration of viability. It is here that mediation provides space for that restoration. Beginning for now, India's dispute services must not treat arbitration and mediation as competing pathways. They are complementary instruments in a single architecture, one providing finality, the other flexibility, one delivering adjudication, the other understanding. At this point, I also want to speak shortly on the significance of the first edition of the India International Dispute Week. The name is slightly problematic with me. I would have loved if it was India International Dispute Resolution Week, but which is poised to be a week-long deliberation on various pressing topics. As someone who has organized and participated in hundreds of conferences, both domestic and internationally, I would want to offer some words of advice. This gathering must not remain a well-organized assembly of eminent minds nor a ceremonial convergence of expertise. It must evolve into a platform of consequences, a space where difficult questions are not avoided but addressed, where enforcement challenges are debated candidly, where technological disruption in arbitration is examined honestly, where mediation is not romanticized but professionalized, and where institutional standards are aligned with global expectations. And I am happy to see that the very structure of this inaugural edition, which I just saw, some of the articles spanning litigation, arbitration, mediation, digital evidence, third-party funding, and institutional governance, all together reflect intellectual seriousness. It signals that we are not content with episodic reform. We are thinking in terms of direction, durability, and design. If DW continues with this seriousness, inviting comparative dialogue, encouraging institutional collaboration, and examining performance rather than posture, I am sure it will quickly become irreplaceable. As I draw these reflections to a close, I want to circle back to my opening thought regarding Chandigarh city being an exercise in intention, not an accident of geography. The renowned architect behind it, Le Corbusier, once observed that a city must be, and what he said, I quote, a place where the mind and the body can find balance. That balance did not emerge spontaneously. It was designed, measured, and sustained. So, dear friends, dispute resolution institutions demand the same discipline. Between now and 2030, India's cross-border disputes framework will not be judged by the number of statutes we enact or centers we inaugurate. It will be judged by how consistently we uphold neutrality, how predictably we enforce outcomes, how swiftly we resolve disputes, and how responsibly we adapt to change. As we have just now inaugurated the Chandigarh International Arbitration Center and the first edition of India International Dispute Week, we are not merely making a beginning. We are assuming our responsibility to ensure that India is not only a fast-growing economy, but a reliable jurisdiction, not only in participant in global commerce, but a guardian of the disputes. If we approach this task with the same deliberation with which this beautiful city was planned, then the institutions we build today will endure long after these proceedings conclude. If you do this well, India will not merely resolve disputes, it will command trust. And in cross-border disputes, dear friends, please remember, trust is the true seat of jurisdiction. Thank you very much. Thank you for giving this opportunity.